198, 199, 210.
If I may be allowed 3 minutes to reply.
3 minutes. Go ahead, counsel.
Thank you, Your Honor. May it please the Court, my name is Stephen Carter Gaynor, and I represent the defendant appellants in this case, Costantino Argyris and John A. DiSalvo. 14 years ago, in Florida v. JL, the Supreme Court of the United States created a bright-line rule designed to deal...
Is that still good law, counsel?
Is
that still the law in New York? Do we depend on that case?
I would suggest that this Court should adopt a rule that makes it clear that that is and should be the law of the State of New York.
Isn't this fact pattern a bit different, though, than Florida JL? Because here you have a caller who is professing to have actually contemporaneously viewed the gun.
I think
isn't that a bit different than the Florida case?
Not really that different for this reason. In this situation, we are dealing with the fact that predictive information, which is an important component here, is not to be found.
Well, I think that's my point, counsel, because there's a difference between a caller saying to the police, you know, there's a red Mustang 2 blocks away and there's a gun in it, from a caller saying, I saw someone place a gun in a red Mustang that's now, you know, 2 blocks away.
But I think
isn't there a difference in the reliability factor of that information?
I don't think with respect to the reliability there is a difference, and here's the reason why. You have, in this situation, you have a reason, excuse me for a second. I'm having a little bit of a...
Certainly.
Go ahead, take your time.
Excuse me. What we're dealing with here, excuse me for that. What we're dealing with here is, thank you very much. What we're dealing with as a starting point, I believe, is that all 9/11 anonymous callers are deemed to be suspect. You can't accept at face value the fact that they're reliable merely because they've made a call that says, I want to report a crime of some sort.
Right.
And I would submit that where they say, not only do I want to report a crime, but I saw a gun, that's no more reliable than anything else they're saying until, I submit, there's some way to corroborate their
Which of our cases in New York say that?
Excuse me?
Which of our cases in New York support your position? We understand you're citing Florida versus JL. What of our cases are on point in terms of predictive behavior?
There are 2 cases of this from this court that specifically say this court and this state should follow Florida v. JL, which created the predictive information rule. And those 2 cases are People versus Moore in 6 New York 2nd, right, and People versus William 2.
Right. Of course, we have to follow the Supreme Court's interpretation of the United States Constitution.
Yes, you have to follow.
But have they cut back on it in Navarrete now, and should we follow them if they have?
Well, yes, we have to follow the Supreme Court Fourth Amendment in our jurisprudence normally, but there is a very, very long-term and glorious record of this court relying upon the New York State Constitution.
So New York is stricter in this regard, and Navarrete is not something that your argument is we should not follow Navarrete?
Well, my argument is...
Or is Navarrete controlling of your particular situation? And if it is, you're arguing we should not follow it?
Well, Navarrete...
That New York should follow its prior precedent?
Well, the thing with Navarrete is this. Navarrete is a decision of the Supreme Court in which the Supreme Court used a totality of the circumstances test. That is something that has never really been viewed with favor by this court in dealing with
So
search
under
and
our
seizure.
state constitution, we would not use the totality test?
Under Article 1, Section 12 of the New York State Constitution, we would urge this court to say, just as it said in a whole bunch of cases, and I can just point to some right now, People
Go ahead.
versus Garcia in the year 2012, People versus Weaver, I know a case that you're familiar with, Your Honor. Going back more years, People versus Johnson, People versus Torres.
Let's assume we do that. In this case of Argyris and DiSalvo, what should have happened?
What should have happened? What should have happened was that when there is a 911 caller, 911 caller, making a call and saying that there is a gun being placed in the rear of a particular vehicle, and here's the license plate. Under New York law and under Florida VJL before Navarrete came down, there could be no action taken by the police unless there was the ability to find predictive information that could be used to corroborate.
What would that be, for example? Or
What would that
could
be, for example?
Yeah, what could that be, for example?
If this was a legitimate informant trying to be a good citizen, he could have said, I saw a gun being placed in the back of a vehicle, for which he gives a license plate number. But the license plate number and the make of the vehicle are evident to anybody standing on the street. So that doesn't give you any information that suggests this informant
But if he says the guy is going to the following address, and the guy in fact goes there, then you'd be within Alabama.
You were reading my mind, Your Honor, and that's what I was going to say. If there's a statement, the fellow who just placed the gun in the trunk is going to be driving to this address in front of the bank, and they're going to go in and rob it.
Okay,
But in this case, let's shorten that up, and let's assume that information's not there. What should they have done then? Just hung up?
Not hang up. What they can do in this case, there was not a scintilla of predictive
So
information.
hang up. You just say, this is a crank call. The fact that you saw a guy with two white, bully guys with bulletproof vests and a gun getting into a Mustang with his license plate, that's a crank call. Move on to the next one. There might be more important calls.
Or the police can put it out over the police radio, and police in the neighborhood can see if they observe the vehicle and perhaps follow it to see what they're doing.
What happened here?
Excuse me?
What happened here?
What happened here was
They went and found the car, they followed it, and they arrested him.
well, they arrested him and then did a dangerous cutoff of the vehicle.
That's a different issue. If you don't like the way the cops are driving the car, that's one thing. But the fact of the matter is that everything that the caller said was true, and it seemed like it was a pretty good description of what could be a very dangerous situation. Let's assume for a minute that these people were going after someone's spouse. And we say, well, that's not quite enough, and then someone's dead, and we say, well, you know, all he did was say it was a guy with a gun and a Mustang and a license plate, and that wasn't enough for us.
But if the police had followed the vehicle that was there, the Mustang with the license plate number, and had followed it to see if it was going to go to some address and maybe do something when they were getting out of the car, the police could have gone over to them, exercised level 2 of the bore rather than level 3 of the bore, which this requires when you do
So
the enforceable
counsel,
stop.
they, in this case, they follow, some of the officers follow them around, say they're just kind of going around. Is there anything that happens at any point in time in this case that's corroboration?
In this case, there was no corroboration because the police ended any ability to find some form of predictive information because they pulled over the vehicle, approached the car, first one officer with a gun drawn pointed at the occupants, then 8 cops with guns
So
drawn.
is your point that the person who pulled him over was the person who only knew about the anonymous tip as opposed to anything else that had gone before that?
The person that pulled them over
Yes.
had heard on the police radio about this vehicle, saw the license plate,
And that's all they had?
and that's basically all
Because
they had.
some of the other officers had something else. Would you agree with that? They had followed him. One had
Some
said
movement
pulled
of the
over, and
vehicle.
then they divide, right? The van goes one way, the car goes another way.
But there was nothing inherently suspicious about that act.
Well,
There was
but
no
what
indication.
I think Judge Rivera is getting at is, do we have to view the reasonable suspicion here based on what Valles knew, the arresting officer, since he didn't know what all his fellow officers happened to know, if they had told him things, he can rely on them. But aren't we limited to his knowledge for purposes of judging reasonable suspicion?
I would say yes, that we are. But the point is, it seems to me, based upon the readings of this Court over the years, is that there are going to be times when, because of the pursuit of freedom and having a set of rules that protects the populace of this state.
Counsel, would it be a different case if the officer, if an officer had heard the call, follows them, sees the car, sees the Mustang, sees the van, follows them, sees them just driving around, asks them to pull over, and then sees them split? At that point, could that officer have stopped them?
Asks them to pull over and
Yes.
they split?
Correct.
Yes, I would say they could. But if I just might...
Except that you say he couldn't have asked them to pull over in the first place.
That's correct. But if, let's assume they're stopped at a light, there's nothing
But
to
you say, watching them drive around, perhaps aimlessly, you say that's still not enough to ask them to pull over.
The point that I was going to make a few moments ago, and I'd like to make right now, if I may, is this.
As long as you get to the answer, eventually, yes.
And here's an important answer, I think, for my argument. That is that when one looks at the history of this Court in Article 1, Section 12, sometimes, instead of using a totality of the circumstances test where you're taking from this fact or this factor, and it's not always the clearest guidance for the courts of the jurisdiction, a totality of the circumstances test. That's why this Court rejected it when Illinois v. Gates was decided, and two important decisions of this Court said we're going to stay with Aguilar-Spinelli and get rid of Illinois v.
In our
Gates.
reasonable suspicion cases, though, we haven't been using Aguilar-Spinelli. We've been using what amounts to a totality of the circumstances.
Well, with all due respect, you've been using Aguilar-Spinelli.
I'm talking about the reasonable
suspicion. With respect to reasonable suspicion, there are no cases in which Aguilar-Spinelli has ever been applied to the reasonable suspicion test. There's not one, and I submit there's a reason for it, and that's because Aguilar-Spinelli doesn't work when it comes to reasonable suspicion.
Why doesn't it work when it comes to reasonable suspicion?
Aguilar-Spinelli doesn't work when it comes to reasonable suspicion for this reason. Aguilar-Spinelli is a two-pronged test. One of the prongs is the reliability of the informant. The other is the reliability of the informant's information. It's our position that an anonymous 9/11 caller who doesn't disclose himself and who's and there's no question that the informant, the 9/11 caller in this case, is anonymous. That person can never be deemed to be reliable, and therefore the test doesn't work.
I counsel that anonymity is a problem, but we have all these admonitions out here to the public. If you see something, say something. And so when is it that we could ever rely under your theory?
Well, I think all the people have to be told is if you see something, say something, and give your name to 911. That's
one of the problems with that, and it's become a big deal in the cities, is what they call snitches. And, you know, there's this big thing, snitches get stitches, and there's whole communities that say, you know, if you snitch, you're dead. So what we're saying is you've got the skill in Charybdis. You can either tell us who you are, and we'll try to pursue the miscreant, or don't, and we won't. So if you tell us who you are, you're going to be dead. If you don't tell us, we're not going after them.
I'm going to try to make this one point, if I may, because I've been trying 3 or 4 times now, and it addresses all of these questions. The history of this Court says that you have to know. The history of this Court says you have to know that there will be times when we come up with these very good rulings relying on the state constitution when sometimes the guilty person walks away.
It's worse than that. Sometimes even more crimes get committed and people get killed. And we understand to some degree that's the price of freedom. But we're asking a narrower question, which is it really a good idea to send the message to the public, if you want to call anonymously, don't bother, we're not interested?
I think it is a good rule for this jurisdiction, for this state, to say that it's not going to take automatic police action based solely upon the uncorroborated statements of...
No, I'm sorry. Then I've misunderstood your argument. I thought your argument was that, of course, you take the anonymous tip, and you're law enforcement, you decide what to do with that tip, and what you might do with that tip is follow until you get corroborative information to then act appropriately on the tip. Have I misunderstood your argument?
No, that is essentially one of the things that I said earlier today, and I stand by that. I do believe that is a valid statement. But with respect to this sign, you know, if you see something, say something, that's meant to deal with an age of terrorism and things like that, where people are being advised.
Well, if you see 4 big guys wearing bulletproof vests, putting a big gun in the back of a car, followed by a van, what do you think people are thinking about that? That they're not up to, you know, great civic activities.
Well, we don't know from this record what kind of gun we're even talking about, because they're just talking about a big gun.
Well, there never was a gun in the trunk, was there?
And there never was.
They never said there was a bulletproof vest, did they?
They never said there was a bulletproof vest.
Okay, Counsel. You'll have your rebuttal. Let's hear from your adversary.
May it please the Court, my name is Donna Aldea, Barquette Marion, and I represent the people pro bono on this appeal. Your Honor, to follow up on that question, I maintain that if defendant is right, every one of those signs has to come down. And there's a wisdom to the ad campaign which is reflected in Florida versus JL, long before that in Alabama versus White, in the Supreme Court's recent explanation in Navarrete, and in this Court's jurisprudence dating back to when it refused to adopt Illinois versus Gates and adhere to Aguilar-Spinelli. And the wisdom in that ad campaign are the words, if you see something. Because reliability is given.
But it doesn't matter whether we know who you are, doesn't it?
Well, Your Honor.
It does have some relevance.
Of course it has relevance. And the relevance under the state constitution, which I'm perfectly happy with adhering to or not, as this Court chooses. State constitution is part of it.
Please stick with our precedents.
Perfect.
And let's assume that Navarrete goes in a little different direction. Well, how does it affect this case? Our precedents, what should the police have done in this particular situation?
They should have done what they did. Our precedent in this state has been adherence to Aguilar-Spinelli, and I need to clarify something.
Go ahead.
It is true that Aguilar-Spinelli has never been applied to reasonable suspicion determinations. However, that's not because it's inapplicable. That's because it's the strictest test that has ever been construed or conceived of by any court anywhere. You don't need to satisfy that really hard test of Aguilar-Spinelli for the lesser standard of reasonable suspicion rather than probable cause. Instead, less than Aguilar-Spinelli will do. What I'm telling this Court, which is what I told the suppression court.
Is it a so-called totality of the circumstances test for reasonable suspicion?
Correct, Your Honor. However, what I will acknowledge is in the context of anonymous tips, the standard has always been higher. And that's what JL really is about. JL is an acknowledgment that totality of the circumstances may be a little too lax when you have an anonymous tip.
So are you talking about some variation of Aguilar-Spinelli?
Yes, Your Honor. So what I'm talking about, I'm saying you can apply Aguilar-Spinelli itself. In fact, when you read Navarrete, interestingly, it might as well have adhered to both prongs. Here's the rule of law, going back to Judge Lippman's question about what the rule of law is in New York. The rule everywhere, not just in New York, has always been that reliability of criminality, as opposed to just reliability of the person himself or of observations and descriptions, is satisfied by personal information, personal observation of criminality. Now, what was lacking in Moore, what was lacking in Williams, what was lacking in
Yes, but
JL,
at some point, you have to be able to measure whether or not you can really trust the quote-unquote personal observation, because in an anonymous tip, I can just call up and say, yeah, I saw the guy with a gun. You don't know me. You don't know my track record like a confidential informant, so you have no basis by which to measure it. Just in that statement, whether or not it's true, whether or not I'm just hoping that a cop will stop this person who I don't like and hassle them and maybe find a gun on them, maybe not.
So there are two answers to that question.
Yes.
I'm going to try to actually give both.
Yes.
The first answer to the question is actually you can, because here's the way it works. Under Elwell, under DiSalvo, these court's seminal decisions, what this court said is observation. So we have these two prongs, basis of knowledge and then veracity. Under the basis of knowledge prong, this court has said you can satisfy that in one of two ways. Either by a report of personal observation, which is itself sufficient, or if that's lacking, then we need predictive information, we need corroboration of criminality. So Judge Rivera, I'm sticking with
the only reason that you're allowed to self-report What you saw is there's a veracity prong. You can check out whether the guy's reliable.
But the veracity prong is satisfied, has always been, and this is directly out of Elwell, has satisfied by details not necessarily indicative of criminality, by details that do not contain predictive information. Here, veracity is satisfied by observations of Ruth's mannerisms, the description of the people, the description of the car. But I want to get back to Judge Rivera's question, because there were two prongs to the answer. So there's a logic as to why predictive information is only needed when basis of knowledge is lacking. And the court in JL said it. It's needed because it has to, by necessity, be one or the other. It cannot be both. They're mutually exclusive. For example, if I'm an individual citizen, like this guy, a private citizen who's coming out of a house and sees something on the street, I can't possibly have predictive information. I don't know what the criminal is going to do. I don't know the criminal. I'm not a snitch. I'm not involved in the criminal behavior. I saw something. So in that case, I can't give you predictive information, but I can satisfy that test by saying I saw it.
Yes,
I know.
I understand what you're saying. You're collapsing these two. I get the point. But here's, I think, what I see as a problem to what you're arguing, which is that's all fine and dandy when the person's doing exactly what you say. They're trying to call and say, yes, that's what I saw. I want to give the police heads up. But we are also concerned with the person who's malicious, who's not doing that. That's what we're trying to protect against.
Yes, Your Honor.
So doesn't the law then say that although the gentleman that you're referring to, and the gentleman in this case, can make the call that you're saying, look, I saw something, it's like the sign says, I saw something, I say something, up to you what you want to do with it, isn't the law then, okay, the cops now have, they can decide something to go on. They can pursue this to see is there something corroborative there, because he has given nothing more than just identification information that anybody on the street could give. There's nothing that makes that phone call unique or special.
Well,
right?
Your Honor, now I have three answers to the question.
Very
Going
good.
back to the
Go
second
for it.
one was this. Actually, when we look at the malevolent tipster, the private citizen on the street who doesn't have predictive information, who sees a random guy at a bus stop and describes what he's wearing, has no incentive to frame the guy. You know who does have an incentive? Someone who knows him, who has an axe to grind. So actually, the test that my counsel is promulgating that Your Honor is talking about, if predictive information is sufficient, it doesn't weed out a malevolent tipster. To the contrary, predictive information would be possessed particularly by a malevolent tipster who has an axe to grind and who would say,
that malevolent
I know he's going
that
here.
malevolent tipster may not want to reveal themselves, because if they give you too much, you know who they are, and they might be worried about that.
Well, Your Honor, that's a different
So let's go
story.
to whatever was point 3 that you wanted to make.
Well, the second point is that certainties are not required. We're not only talking about probabilities for probable cause. We're talking about less than that for reasonable suspicion. So the law is not, constitutional law is never a prohibition. Constitutional law is a balance between two competing interests. And that balance is struck by weighing individual liberties on the one hand, applying this very difficult to satisfy Aguilar-Spinelli test, which, going back to Judge Littman's question, you only need to satisfy both prongs when you do have anonymity. Because a private citizen who's identified doesn't have to.
How does the balance set in these particular set of circumstances?
Now,
what's
here,
the balance here?
The balance here works out even better. Because, and this is going to answer 3 to Judge Rivera's question as well. Here, we not only have the situation where we have both the basis of knowledge satisfied by personal observation and veracity satisfied by observation of details not indicative of criminality. More than that, we have the call in evidence. And that is crucial. Because just like the Supreme Court reasoned in Navarrete, and just like this Court has reasoned in prior cases, when you have a citizen who remains on the scene, he's still anonymous. He can't be found, he can't be prosecuted, but he's presumed reliable because you can listen to his reliability. Aguilar-Spinelli and this whole rule is really a hearsay prohibition. That's what is at the root of this when you look at the history of these rules. Hearsay is inherently unreliable. If you don't know the source of it, it's even more unreliable. Here, we had the call. So when we listen to it, we know that the caller was credible. We know this from a number of things. He describes contemporaneously what he observed. The criminal activity that he describes is unconcealed. It's a gun on an open street. He describes details about license plates, mannerisms. You can hear in his voice that this guy is not only excited, he is scared. And I urge this Court to listen to that tape because he says, oh, no, the guy with the gun, I didn't see what they were wearing. The guy with the gun saw that I saw him, so I ducked into my car and played stupid. Those are traditional indicia that imbue regular hearsay with reliability. Navarrete relied on it.
And you would say that we should, basically, we are allowed to consider this case as though the arresting officer had heard the tape because the 911 operator did.
Correct, Your Honor.
Okay, but isn't it also true that we're limited to what the arresting officer knew either at first or second hand? We can't rely on the aimless driving, the car, the splitting up of the van.
No, Your Honor, that's not correct. And the reason for that, it wasn't briefed, it's not really an issue before this Court, but as background, there's a fellow officer rule. And the fellow officer rule... The fellow officer rule applies when you haven't even spoken to your fellow officer? Well,
you have no idea what he knows?
Yes, Your Honor. It applies because there's a directive to stop the car. And so when you go after the fact and look at the information that was possessed by the police department, the information includes or extends to what all of the officers at the scene knew.
You got a case that says this?
I didn't brief it, so I don't have the case now at the tip of my fingers. I can't think of the case.
The Chief might give you permission.
But it is. Okay.
You're saying the fellow officer rule includes a dispatch from headquarters to all cars?
It does, Your Honor. And in this case, in fact, what I would say is that actually the report that went over the radio contained these salient details as well, that there was a guy with a car, the observation of criminality, all of that. But reliability gets assessed after the fact, in a sense. Probable cause or reasonable suspicion is established. This actually is a broader principle, and I really do need to address this. One of the flaws in the reasoning that my esteemed adversary takes before this Court, and in some of the questions here, too, is that there's a difference between whether information is sufficiently reliable for the police to act upon it and what level of suspicion it confers. So it's not correct to say, as Judge Rivera's questions were suggesting before, that an anonymous tip can only ever give you a level 2 right of inquiry. The question of whether the information is sufficiently reliable to act upon traditionally is gauged under the hardest test by Aguilar-Spinelli or by totality of the circumstances under Illinois versus Gates or something like that. The question of what action you can take depends on the content of the information. So once you determine it's reliable for the police to act on it, if the police are saying, if the caller says, I saw a waistband bulge, well, that's not the same as the caller saying, I saw a gun, which may not be the same as the caller saying, I saw a bomb, and the time on it was 30 seconds. So the content of the information matters. And I'm not making this up. In fact, Navarrete, actually, it's interesting. I don't agree with most of Judge Scalia's dissent, but I do agree with the portion where he actually breaks down the analysis, as did the majority, into those two separate issues. First, we look to, is the information sufficiently reliable because it contains the basis of knowledge and corroboration of other details, sufficient description. The second prong is, okay, it's sufficiently reliable, which means the police don't have to hang up, as Judge Piggott said. They can take action. The level of intrusion, which under this Court, under the State Constitution, is governed by De Boer, is dictated not by the reliability. We're done with that. We've already crossed that prong to allow the police action. The level of the intrusion is dictated by the content of the information. Because a police officer who sees a bulge doesn't take the same action.
But, counsel, I still don't see, as I understand your argument, you're saying that someone could call up and even say, I saw Jenny Rivera with a gun walking down the street towards the courthouse, and they can just stop me.
Correct.
They won't say who they are. They won't say anything else.
Correct. Because, but again, my point is this. When you look at the rule that this Court's going to create, I absolutely, completely understand your concern about the malevolent tipster. It is, I can't eliminate it.
We have to create a rule here? You don't,
No.
You've already said you don't need Navarrete. We're talking about our basic precedents. Do we have to create a rule, or is it clear? And it's clear that the situation that Judge Rivera just asked you. It's clear they see it, walking down the street, gun, great, we stop you.
Correct.
That's our present, under our precedents, putting aside Navarrete. based on Florida versus JL and then the things that followed. That's the rule.
Well, Florida versus JL is a Supreme Court case, so there's something
Yes,
odd
but
about
then we have
saying-
our cases that
Right.
follow that,
Well,
William II,
actually,
et cetera.
Yeah,
right?
no, actually, our cases don't follow that. Our cases precede it. So Elwell, which is the case that sets this up
Right.
into basis of knowledge, DiFalco, which sets this up,
Right.
these are cases that precede Florida versus JL and Moore and Williams. What I'm
And
saying on Moore and
William
Williams...
II and Wright in all of those cases.
Yes, so you don't need to change the law. In fact, I think all of the law is actually consistent on this point. In Florida versus JL, the Supreme Court came back a little bit from Illinois versus Gates. My point has always been this. Florida versus JL is not an inconsistent rule. If I can satisfy that, I can satisfy anything else, because there's never been a tougher test. And my point on Moore and Williams and JL is you necessarily have to interpret that broad language. And I acknowledge the Court said an anonymous tip standing alone can never be sufficient to furnish reasonable suspicion in the absence of predictive information. True. But that case is by necessity limited to the facts before this Court, because otherwise this Court overruled Elwell and overruled DiFalco and overruled all of Aguilar-Spinelli by finding that the basis of knowledge prong is not satisfied by personal observation. And in Navarrete,
We
again...
couldn't have done that, right?
No, Your Honor. You didn't do it because if you had, then you would have had to have said that that's what was going on. So, again, going back to Judge Rivera's question...
Basis of knowledge because you have some reason to be able to measure whether or not this is a true statement as opposed to...
No, Your Honor.
I won't even say malicious. Someone who's just wrong.
Correct,
They thought
Your
it was a gun, but it was my umbrella.
Your Honor, you can never eliminate the risk that there may be probable cause or police intrusion based on a mistake. You can whether you have an anonymous caller or not. You can never eliminate the risk that a malevolent caller might target you. But what I'm saying is, defendant's version of what the test should be, which really is a sea change in the law, is not going to address Your Honor's concerns.
But the point is, counsel, any call is not enough, right? There's got to be some rules. It's not just someone, anyone, whoever in the world it is, sees her with the gun or the umbrella, and that's enough. You can stop. It's where do you draw the line? So it can't just be the simple answer, I think, to Judge Rivera's question, which is, yeah, anyone who calls and says you have, great, we're going to stop. There's got to be some kind of standards, and that's what you're trying to lay out. But it's not any caller, any time, stop everybody. Clearly, that's not the rule.
I agree with you, Your Honor. And the rule of law, the appellate division actually said it.
Okay.
It is, if you don't apply Aguilar-Spinelli, the lesser rule is what the appellate division said, and this echoes Jeffrey and Moss, which are Fourth Department cases. The rule is a contemporaneous observation of unconcealed criminal activity is itself sufficient to furnish reasonable suspicion. And that's exactly what we have.
Is it practical to tell police to follow that rule? Are all the police in all the towns of New York going to learn that if you have that you can arrest, that if the anonymous call has contemporaneous information of unconcealed criminal activity, you can stop the guy and otherwise you can't?
Well, I would say it's not that otherwise you can't. It's that when you have contemporaneous observation of unconcealed criminal activity that's described, you certainly can.
I'm worried a little more about the general problem. If I'm an ordinary working cop in some town in New York, and I want to know when I can arrest someone based on an anonymous tip. You're my lawyer. Tell me.
Well, what I would tell you is this: is with respect to an arrest. If you satisfy both prongs of Aguilar-Spinelli, then you can get an arrest warrant, which is why I said in this case, if this had been brought before a judge in a warrant, in the context of a search warrant, an arrest warrant, and I had satisfied basis of knowledge by personal observation and corroboration of details not indicative of criminality for veracity, which I do here, then a warrant would issue, which would actually authorize probable cause. So my point is, when we're talking about what guidance do we give the cop on the street, the bottom line is, if you've got probable cause, you've got less. That's guidance one. Guidance two is you need to act reasonably. And the bottom line is the officers have an obligation to investigate a report of a man with a gun. This Court said so in Benjamin. It is not reasonable for them to hang up the phone on a private citizen who clearly, from the content of the tape that goes before the suppression court, saw something and said something. It is not only unreasonable, it is impermissible, and it would be detrimental to our society to enact that kind of rule.
Thanks, Ken.
Thank you.
Rebuttal, counsel.
First of all, with respect to the issue that you raised, Judge Lippman, about not having any caller, any time, it's got to have some structure. The police need some guidance. I just want to address the Navarrete case. Navarrete does not provide that type of guidance. What does is the type of bright line rule that was established in Florida v. JL and the cases that I gave you before. Garcia, Weaver, Johnson, Torres, Grimminger, all New York State cases under the New York Constitution.
And your bright line rule is you can't stop someone on an anonymous tip unless the anonymous tip provided predictive information.
This court said that in Moore and in William II. It said that because it was, following Florida v. JL. But that has been the law for 14 years.
But if you don't have an informant who knows what's going to happen next, how are you going to get that predictive information unless the police do what you suggested, which is to follow this, with these people who allegedly are nefarious? And if they get made as cops, then they're not going to do whatever they're supposed to do. They'll probably wait and then later do it. The cops can't follow them forever. So what would you
And
suggest?
it may be that there will be cases where someone who's got a gun in the car is able to drive away from the scene because the police were not
But what
authorized.
strikes the right balance that your adversary was talking about? How do you allow efforts to stop crime or stop bad people from doing bad things and yet not trample on people's rights? What's the balance in our test? I asked the same question to your adversary. What's the balance here?
I think that I go with the old saying: if it ain't broke, don't fix it. There is, for 14 years, a history of using Florida v. JL, where there is the requirement of at least some predictive information that based
and here
there was
predictive
not a
information.
scintilla of predictive
Let's do a hypothetical where there's a parade downtown Rochester and somebody makes an anonymous call and says, I just saw a student with a knapsack, put it down by a street light, and he walked away.
Okay?
Hang up on that one, right? There's no.
No, you call the police. The
That's
police
who
would
he
go
called.
over if he
He
walked
called.
away and there's a bomb line. I'm sorry.
Well, that's what you don't know, but there's no predictive information, is there?
But there's been something that's been abandoned there, and the cops would have a right to take it
Your
under the
point is
emergency doctrine. I would
Your
submit.
point is they can check out the knapsack, they just can't stop the kid.
And if they detain him just for a moment while they look inside the knapsack, and if there is a bomb, then I think that they can arrest him.
Well, or they could go over, they actually see the knapsack, and before they get to it, the kid is walking away. They could ask him to stop.
Right.
Maybe something happens in that moment that raises this to a different DeBoer level.
So the police ought to pursue that, much like they did in these cases.
What I'm saying is what the cops can't do, I believe, under New York State law, is pull somebody over with guns ablazing and, well, not being fired, but pointed from a lot of different directions when it's all dependent upon the anonymous word of somebody who we don't know who they are, we don't know what they've seen. It could be somebody who's either malevolent or wrong.
Again, you say the problem is that the officer who actually stopped them only knows the tip, doesn't know anything else that has gone on.
And when you look at his examination in the record.
Yes. Can you respond to counsel's point that the dispatch is enough to get the fellow officer rule to apply? She says you can rely on this other information that other officers knew.
It can be used to seize, but then under People v. Lipka, you have to be able to justify. In other words, under the fellow officer's rule, as I understand it, it can be used, and it's right, we haven't briefed it here, but it can be used to take action, the fellow officer's rule, but then afterwards, you have to be able to sustain the basis upon which the police officer acted.
My question of Ms. Aldea was, can you rely on something your fellow officer has never told you? I mean, I understand that if he tells you the conclusion, then the basis for you get the benefit of his basis for knowledge.
I don't think you can.
You also are going to, you don't have a case right with you because you didn't brief it, but
Correct,
maybe there
Your
is
Honor.
one.
But there is one thing I'd like to say that I think is relevant to the argument that we've had today, and I think important, and then I'll
Finish. Good. Last point, Counsel.
All right, here's the point. If you accept this argument that is being put forward by the people about how by saying by the anonymous informant saying, I saw a gun, that somehow makes him reliable, then what you're doing is making it possible for this person who may be malevolent or may be angry or whatever, you're giving them the opportunity to self-validate their own reliability, because they're basing the claim, this inherently suspect person, upon their own thinking.
Okay, thank you both. Appreciate it.
Thank you, Your Honor.
210, People versus Johnson.
Good afternoon. May it please the Court. Edward Fiondoc for the appellant, Eric Johnson. I'm at the low end of the spectrum of what's been talked about here. The major issue I think we have to recognize is I don't have an anonymous tip at all. 4 or 5 days after the 911 call was made, the deputy that stopped my client took a supporting deposition from the 911 caller.
Counsel, before you go on, is that in the record?
Yeah, it's at record page 66.
But it's a record for here, but was it presented to the courts below? I don't remember it being in your
It was never presented to the court below.
Yeah, and it wasn't in your leave application either, was it?
Exactly. In the court below, it is a totally anonymous tip.
So can we deal with it here? I mean, it has to be an anonymous tip here, doesn't it?
It is an anonymous tip here. As you're looking at this case, this is an anonymous tip. But this is an anonymous tip of the very lowest caliber.
Yeah, but what happened here is the police see what conduct that's happening from this person that they're following. They see the bad turn or whatever it is. Doesn't that make this case?
It was described as a hasty or wide right-hand turn.
Right. So isn't that important that the officers saw that?
This officer could not act upon that hasty or wide right turn.
Why not?
Because he was 1.8 miles outside of his jurisdiction.
Yeah, but he saw it.
He saw it.
That's unimportant?
But he did not have the authority to detain the motorist for the hasty or the wide right turn.
Is that the strength of your argument? That jurisdictional thing is the key here?
The jurisdictional thing, I think, is the key on the hasty or the wide right turn. Now, you can look at the hasty.
Counsel, let me interrupt you for 1 second. Do you want any rebuttal time?
1 minute.
1 minute. Keep going. Answer judgment.
The issue about the hasty or wide right turn is it's not indicative of any form of criminality.
Okay, that's so we're away from jurisdiction.
Right. It's not indicative of criminality. Now,
But on the violation itself, you're saying that there's a statute that prevented the officer from stopping this person because it was not in his jurisdiction?
Correct.
And
He only had jurisdiction to arrest the appellant for criminal activity. And the hasty or wide right turn doesn't constitute criminal activity.
Doesn't it tell him anything now?
It's a wide right-hand turn. It's something that I'm sure this officer observed.
Totally innocuous thing?
Totally innocuous.
And what's the basis, just the statute? If he had violated the statute and gone ahead and stopped the person, even though it wasn't in his jurisdiction, would we still be talking about suppressing this?
Well, you wouldn't be able to prosecute him for the hasty or wide.
Suppose he had a sticker on his back window.
Pardon?
Oh, never mind.
You wouldn't be able to prosecute him for the hasty or wide right turn because it would have had to been dismissed as a result of the deputy not having jurisdiction and being outside his jurisdiction.
I realize it hasn't been brief, but isn't there a problem that even if they, suppose this officer had made a stop based on the wide right turn, which was a traffic violation or something, and he was wrong. He's not allowed to do that. Aren't there cases that say, I don't care if he was wrong, if it's only a jurisdictional problem, you don't suppress the evidence?
I guess I'm not understanding the question.
Okay. It's one thing to say that he's not entitled to make the stop under a statute. He didn't violate the Fourth Amendment by making that stop. He just violated the statute that says he has to stick to Yates County and can't go into Ontario County. Is a violation of that statute reason to suppress evidence?
I would respectfully disagree that he didn't violate the Fourth Amendment because he did not have a justifiable basis to stop that motor vehicle.
Well, I guess what I'm saying is he had a basis. There's nothing in the Constitution that says you can't stop a motor vehicle for a violation. In fact, people do it all the time.
Right.
It's an indoor, seems to be a major industry in New York, is stopping automobiles for violations. The Constitution doesn't say you can't do that. Does the fact that a statute says it make it a Fourth Amendment violation?
Well, what we've really done here is we've elevated that wide right-hand turn to a de Boer level 3. He's actually detained the individual. He has seized the individual.
But there are cases where we have allowed a de Boer level 3, a stop, based on things like a non-transparent sticker on the back of the car.
Correct. But that would be with an officer who had the authority to execute that stop. At this point in time, he's no more than a private citizen attempting to do this.
If we did that, then part of the 9/11 call was that there was a sick or intoxicated driver, right? If the officer was concerned, if her concern was that this man or this driver may be sick or intoxicated, could she stop him?
You're saying if the officer had concern that he was sick or intoxicated, but then we get back to the whole issue of whether or not he should be entitled to do that based upon this anonymous tip.
Right. That's kind
I mean, this anonymous tip is so innocuous. This is the type of anonymous tip that you really have to be.
But what about the tip with the turn together? Still innocuous?
The tip with the, yeah, I believe it is, because a wide right-hand turn, we can go out here today, we can sit at any intersection, we can see wide right-hand turns, wide left-hand turns.
It's not unusual for motorists to perhaps call the police, especially now that cars have, hands-free calling, to say, I'm on the thruway, there's a car really weaving in and out of lanes here.
Right.
I don't know if the guy is having a heart attack or what's going on, but or a truck, keeps weaving off the road. Are the police to ignore those calls?
Certainly not, Justice Graffio. What they're really supposed to do at this point.
Tell me what they can do with that. Can they do anything with that?
Locate the vehicle, follow the vehicle, and then look for some confirming evidence that, in fact, this person is having a heart attack, he's intoxicated. Wait to see the vehicle cross a fog line, cross the dotted line.
If the officer sees the vehicle weaving, then he can stop it.
Correct.
But if by the time the officer gets there, the vehicle has righted itself and seems to be driving normally, all he can do is follow. He can't stop it.
He could only follow it and not stop, because you have no indication that the information that had been provided to that police officer, be it sick or intoxicated or weaving or heart attack or what have you, is either reliable or that there's any basis for it. And what we really don't...
We've been worried a lot about the malevolent tipster, the person who
Right.
gets somebody in trouble. Wouldn't it be very unusual for one driver on the road to call in the car in front of him out of spite? I understand you might, if it's your ex-boyfriend or the next-door neighbor you hate, you can get some malevolent calls. But what kind of driver, how often does it happen that a driver says, just for the fun of it, I'm going to call up and give the license number of the car in front of me and tell him he's weaving?
I wouldn't know. I wouldn't know.
I guess what I'm saying is should our rules be tailored to take account of the fact that this kind of tip, though you say it's so weak, is actually quite unlikely to be a made-up, spiteful tip. It was so unspiteful, she didn't even say it was drunk. She said drunk or sick.
I would go to higher authority myself and just point to Justice Scalia in his dissent in Navarrete. He was concerned about that. He was concerned about that malevolent tipster. It could be an ex-wife, and this person's case, it could be an ex-patient or something, sees the car, has a grudge.
And Navarrete would have been an ex-wife who planted a GPS in the car, but I suppose it's possible.
Well,
I'd like to take you to Justice Roberts in Navarrete when he says, anonymous caller says somebody's got a bomb in the car. Are the police supposed to wait before they throw the bomb out of the car before they stop them?
But there are levels of emergency which I think would and definitely in the rule that you establish, if you choose to establish a rule, there are levels of emergencies that there should be a level of adaptability here. Clearly, if it's an issue of a bomb, I would have to concede that, perhaps the police officers may be permitted to go further than they are with simply a sick or intoxicated motorist.
But a sick or intoxicated motorist could certainly hit someone, obviously could kill someone, if not yourself also.
He could, but in this situation, we do have to remember that he'd been followed for a period of time, and the police officer observed nothing aside from the hasty or wide right turn.
Okay, counsel. Thanks.
Thank you, Judge.
Counsel.
May it please the Court, Jeff Taylor with my co-counsel Robert Jeffries on behalf of the respondent. We would respectfully submit that when Deputy Cunningham was making the stop here, while he could not, and to answer your questions, he could not issue traffic tickets for the wide right turn and for failing to signal timely. He could not issue traffic tickets in Ontario County because he was a Yates County deputy. So he had no authority to issue traffic violations. However, Deputy Cunningham testified that he was investigating a crime, and that crime was driving while intoxicated.
Well, your adversary says, though, that the wide turn is totally innocuous.
I don't think
that it's not some obvious, terrible thing that you're weaving between the line. It's a little bit wide turn. What's your view of that?
I do not think it's innocuous, Your Honor.
Why not?
Because Deputy Cunningham testified in this instance that the vehicle was turning from Route 21 in the town of Naples, and when it was making a right-hand turn on Toby Road, it was going westbound, and it went into the eastbound lane of traffic.
It was late at night, wasn't it, Counsel? Couldn't the driver just have had a problem seeing exactly? It was pretty late, wasn't it?
But when the vehicle goes into the eastbound lane, that doesn't mean the deputy doesn't have authority to stop and inquire.
How wide is the roadway? I mean, could have been just a couple of inches into the eastbound lane. Didn't have to be right into the eastbound lane to right itself, right?
I think his testimony was that the vehicle was going west on Toby Road, or on Route 21, and it went into the eastbound lane. So it's in the oncoming lane of traffic when that occurs. So he has a good faith basis to stop the vehicle, setting aside the 911 call as well, when he sees that the vehicle not make its turn signal in a timely manner and also fully go into the eastbound lane. He's going in another lane of traffic.
So you make a lot about the turn signal, but he did put on the turn signal. I couldn't understand why you and the town court thought that was 2 violations and not just 1.
Well, even if it was just the 1 violation going into the other lane of traffic, it is something that Deputy Cunningham sees as well, so he testifies it as well. He indicated the traffic signal went on at the last moment.
That seems to be standard. In fact, usually people are signaling what they're doing, not what they're going to do.
I wouldn't disagree with you, Your Honor, at all. But in this instance...
But you're saying sort of because of the tip, when he sees this turn and it's into the, as you say, this oncoming traffic lane, that suggests to him this is not just merely who's just weaving a little bit off, it's a little bit late at night, but perhaps he's intoxicated or sick, and that's what concerns me.
And the tip, Your Honor, which you're speaking of, is the anonymous caller
Yes,
in this
yes.
instance who described a particular vehicle, a blue BMW, that was on a particular road, Route 245, traveling southbound. And then Deputy Cunningham, doing his job, finds that vehicle, and about 8 minutes later when he travels southbound as well. And what does he see when he comes to the intersection on Route 245 and 21? He sees a blue BMW with a particular license plate of FGB 5675, and it matches to a T what that anonymous caller had reported. Now, at that point in time, the deputy's outside of his county. He's not in Yates County. He's now in Ontario County. But he still has evidence that it was described as a sick or intoxicated driver. He then does the further good things of corroborating what the tip had provided, the 911 caller. He follows that vehicle for a period of time, and then he sees the traffic violation, including, as we've discussed, going into the eastbound lane instead of staying in the westbound lane. So here, Deputy Cunningham did all the things that a good officer is supposed to do.
Without the tip, could he have stopped him?
Without the tip, yes. I do think, or no. Without the tip, he would have then seen just 1 or 2 traffic violations. He himself, Deputy Cunningham, in Ontario County, could not have stopped the vehicle for just traffic violations because he was outside of his jurisdiction.
He'd have no reason to follow him.
But he did have a reason to follow, and that's why he also contacted...
No, I'm saying he wouldn't have had a reason to follow him without the tip, right? Because at the time that he saw him, he didn't see him doing anything that violated the VTL or anything else, right?
Except the traffic, under your hypothetical, he would have only seen the traffic violations for which he could not have issued traffic.
Suppose he had only the tip and not the right turn. Could he stop? Not the wide turn. Could he stop him?
I think that even with just the tip, I think Deputy Cunningham in this instance had an ability to inquire and to follow the vehicle for a period of time, because what he has here is...
I'm not questioning that. Did he have the right to pull the driver over?
I think he does in this instance because it's a particularly described vehicle, blue BMW on a particular highway. He finds it within 8 minutes. And the key thing is here, it's described as a sick or intoxicated driver. And Deputy Cunningham testified that he was then investigating the crime of driving while intoxicated.
So if somebody calls and said, I'm following a car and I think the driver's drunk, can that person be pulled over just on that statement?
I don't know if that's quite enough, because you don't have a description, Your Honor, in your example.
Even describe the car. All right, so now you got a blue BMW. But so far it's staying in its lane, it's within the speed limit, it's doing what it's supposed to do, but somebody said that person's drunk.
The additional factors here, though, include the description of where the vehicle's going from and what's coming from.
I'm cutting back on it and trying to get a more general rule. Can a police officer stop someone solely on an anonymous tip that they think the driver is drunk? That they saw a blue BMW and they think the driver's drunk?
If the information from the 911 call is corroborated by the officer, that he sees a particular vehicle with a particular make and model, a particular direction, and it's also contemporaneous, which is what happened here because it's within about 8 minutes later, I think the officer does have the ability to stop the vehicle. The worst that's going to happen in this instance, and it's happened to all of us, and I'm looking at the human factor, the worst that's going to happen here is the driver's going to be let go. That's all that's going to happen. And when you have a concern, Your Honor, about the people that are making the malevolent calls, there's there's a manner by which people that make the malevolent calls can be prosecuted for falsely reporting an incident. So there are consequences of the people that make the malevolent calls. They can be prosecuted for a misdemeanor of falsely reporting an incident. They could even perhaps be charged with obstructing governmental administration. So there is some consequence to people if they make the false report, or if it's malevolent in some instance. But in the record,
They may not know that you can track them, though.
Excuse me?
They may not know you can track them.
They may not know, but they may not know you can track them. That was brought up in Navarrete versus
Yes,
California as well.
Yes.
With the technology, it's hard to ignore it now. With the technology we have now, people know that calls to 911 are being recorded and traced as well. And I'm
a little troubled by this particular report because at least in Navarrete you had a caller who said, I was run off the road by this driver. In this case, all you have is you have ambivalence. I don't know whether this driver is drunk or sick. So, you know, there seems to be a little bit less here, a lot less here than even in Navarrete.
Actually, there's more here than in Navarrete, Your Honor, because in Navarrete, the facts in that case, they did not find a traffic violation. The vehicle was fouled in Navarrete versus California for about 5 minutes, and there were no traffic violations, but the police officers still stopped the vehicle. And here, what kind of particularity do we want the 911 caller to describe? She indicated a sick or intoxicated driver. It could have been either or both or neither. But the officer then does.
She didn't describe, or the person who called didn't describe what they saw. Was the car weaving in and out of traffic? Was it, you know, speeding? There was nothing other than, I believe there's a car with a sick or intoxicated driver. Nothing else.
There was much more. There was the license plate. There was the make and model of the car.
Besides the description of the car, but there was no description of the activity which led to the conclusion that the driver's either sick or intoxicated. That's what I'm asking.
Yeah, but these kind of calls, Your Honor, are being made right now where the police are responding to these kind of dispatches, and the type of calls that are being made, they don't always have all the full further particulars. But when you combine it here with what the deputy saw, it's borne out too in the record too. But it's not part of the argument here in the sense that her statement is part of the record, and she indicated what she saw when she called in this particular 911 call.
Was there something more than what she said?
She described that the vehicle was going was crossing the white and the yellow lines. That's in her statement, which is in the record. And there's an argument here that perhaps that witness should have been called as well.
But that's the problem that I pointed out to your adversary. That wasn't part of the record below. It was only here. Well, that only came out here.
Under this Court's decision in People v. Paris, we're not required to call each witness that potentially might be a trial witness, for example, at a later time. For reasonable cause, we have to call the witnesses that are going to set forth the good faith basis for the deputy doing.
Even her affidavit or whatever she gave was not before the trial court, was it?
It was not. But then we still had the officer that saw those traffic violations and was corroborated by what he saw. Thank you,
Okay,
Your Honor.
thanks, counsel. Rebuttal, counsel.
Yeah, a couple of points. Number one, if we're looking at the situation of whether this, we're here talking about Aguilar Spinelli because that witness wasn't presented at the hearing. That witness clearly could have been presented at the hearing. Failure to do that has got us into this situation where now the people are calling for an abrogation of the Aguilar Spinelli test. I find it very interesting that my noble adversary says that he could not stop him for the traffic violation on its own because, in essence, what does that do? That takes us to the tip. And now we have to look at the tip. And what do we have in the tip? We have a sick or intoxicated motorist, uncorroborated, no reliability, no showing of a basis of that tip. That's all we have. So if he agrees that he just could not have stopped for the traffic violation alone, we have to look at the level of this tip. We have to look at how little was contained in there. We have to look at the possibility of malevolent use of the 911 system. I like Justice Pickett's question about, I think the driver's drunk. In that case, yes, but there was no corroboration observed by Deputy Cunningham. And I would further point out that the findings of fact below merely said hasty or wide right turn. Below, the trial court did not find that he nearly went into the other lane or crossed any pavement markings or anything like that. The findings of fact below were simply that it was a hasty or wide right turn. And that was it.
Okay, counsel.
Okay?
Thank you. Appreciate it.
Thank you.